Nevada Transportation Authority's regular general session meeting. We are back from lunch. We are, if I'm correct, on now item number 84. Ms. Babcock.
That is correct. There are two stations. There's usual about either one. So if you wanted to take those in blocks, do so.
Commissioners, any questions on items 84 or 85?
I have none, Chair.
None for me, Mr. Chairman.
Do we have any public comment on items 84 or 85?
No one is approaching.
Perfect. I will close public comment. There's nobody with their hand raised, is there?
No, there are no hands raised on that.
Okay. I will close public comment, bring it back to the board. I need a motion for items 84 and 85, please.
Chair, I'll make the motion to approve items number 84 and 85 on the agenda.
Have a second?
Second?
We have a motion by Teddy, second by Zoka. We have asked for public comment. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. That takes us now, Ms. Babcock, to items 86 and 87. Applications for certificates of public convenience and necessity to provide charter bus service.
Yes, and there is nothing unusual about either one of those, and they can be voted in block as well.
Commissioners, any questions?
None from me, Chair.
None for me, Chair.
Is there any public comment on either items 86 or 87?
No one is approaching.
There are no hands raised online.
Looking for a motion. Hold on, and I have to answer the door. Come on in.
Mr. Chairman, I move that we approve agenda items 86 and 87 as noticed in the agenda.
I'll second,
Okay.
Chair.
Okay, I have a motion by Mr. Zoka, second by Mr. Teddy. We have asked for public comment. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. Ms. Babcock, that now takes us to items 88 and 89.
Yes, sir. These can also be taken in block. There are two applications for the same carrier. The first one is for item 88 is for an increase of authority from one vehicle to two. And item 89 is a sale and transfer, internal sale and transfer from three members to two members, and staff supports them both.
Commissioners, any questions?
None from me, Chair.
None for me, Chair.
Is there any public comment on either 88 or 89? Those are docket numbers 2504005, 2504006.
No one is approaching in Las Vegas.
No one, I see no one's hand raised online. So, did I have a motion? I'm sorry, I don't think I did.
Several.
Not yet.
Chairman,
Yes, ma'am.
briefly, I apologize. I was just noted, number 88, in the blurb, it says CPCN 1155 sub 1. I was told the order says sub 2. So
Sub 2 was moved to sub 3, it looks like, on the order. The end.
If I may, the orders were written so that one gets approved and the second gets
Okay.
approved, and then there's one certificate.
oh, so they trickle down. Okay.
Yes.
Okay, perfect. Thank you. I just wanted clarification.
Yeah, sorry,
Thank you.
I should have.
No, that's okay. Thank you.
It looks like it's
Perfect.
okay, Chairman.
Perfect. Thank you so much for that clarification. I appreciate that. Looking for a motion.
Mr. Chairman, I move that we approve agenda item 88 and 89 as noticed in the agenda.
And I'll second, Chair.
I have a motion by Zoka, second by Teddy. Is there any public comment again? 88 or 89?
No one is approaching in Las Vegas.
There are no
Okay.
hands raised on.
Thank you, Mr. King. I apologize for stepping on you. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. That now takes us, we have a kind of a bit of a situation here. I'm going to let Ms. Babcock explain. We can block part of these, but we need to listen to one. Go ahead, Ms. Babcock. We're on item number 90.
All right. 90 and 91, they are requests to extend their compliance periods. Item number 90, the signature date on the order was December 9th of 2024. And the signature date on the number 91 was 4/18 of 25. Just give you a concept of how old they are. And staff supports both based on their requests.
So in my notes, Ms. Babcock, forgive me, I have that we can block 90, 91, and 93, but we do need to hear 92. Is that correct?
That is correct. Would be a discussion on that one item.
Okay. Commissioners, any
I'm sorry.
questions? I'm sorry.
Sorry, I didn't realize you had included 93 in that when you spoke earlier.
Yes, so Commissioners, any questions on 90, 91, or 93 in a block?
None for me.
Not for me, Chair.
Is there any public comment on items 90, 91, or 93? Those would be docket numbers 24-05012, docket number 24-09008, and docket number 25-01002.
No one is approaching in Las Vegas.
Chairman, Miss Elias did have her hand raised, but put it down. I just want to make sure she.
Elias? Miss Elias, are you still with us? Did she get kicked out of the chat, Jace?
But her mic is muted and I cannot unmute it myself.
Okay. All right, we'll move forward then. Commissioners, looking for a motion for 90, 91, and 93.
Mr. Chairman, I move that we approve agenda items 90, 91, and 93 as noticed in the agenda.
I'll second that, Chair.
I have a motion by Zoka, second by Teddy. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. Ms. Babcock, that takes us back to item number 92, which is docket number 24-11018.
Yes, when companies ask for compliance extensions, they're granted a 90-day administratively. Anything beyond that comes through the agency, through the authority rather. And we ask that they give us, a reason for it and documentation to back it up if they have any. This one is asking based on current unstable financial situation and restructuring, which current unstable financial situation is not an extenuating circumstance.
That raises a lot of red flags with me, Mr. Chairman. One is the restructuring issue. We approve applications based on a known set of owners. Also, if they have trouble financially as they're going into the business, there are a lot of costs, including insurance that have to be borne by the applicant. And if they're having trouble now, it's not gonna get any easier. So I will probably still vote to approve this particular request, but I would like to have a language in the order that no further extensions will be provided.
Okay, do we have anyone wishing to speak on this item? Because I've got a couple of different people listed on this. Mr. Alvarenga, and then a Mr. Humphreys. Are either one of you available?
There's no one here in Las Vegas.
Okay. And no one
Steve
online?
Humphreys from Reno, Nevada. Can you hear me?
Yes, sir, we can.
Yes, sir. Hey, we were number 91. I think that you called my name just now, but I think ours just was approved. I just wanted to confirm that.
Maybe I pulled it. I have your, Mr. Humphreys, I have you as 92. Oh no, my bad. I apologize. I clicked on the wrong item. Forgive me.
Oh, no problem at all. So we can go ahead and disconnect, right?
Yes,
For
sir.
number 91.
Yes, sir. Yep, you are fine. I apologize for that. I just clicked on the wrong item.
Thank you so much. You guys have a good day.
Thank you. I'm blind in one eye and can't see out of the other. So 92, do we have anyone wishing to speak on 92?
There's no one here in Las Vegas.
Okay. So commissioners, I'll entertain a motion if you do want to grant an extension, or what's the desire of the board?
Chair, from my perspective, I'm willing to grant the extension. I second what, Commissioner Zolka has said, that I believe beyond this, it should be substantially, explained as to what the hardships are to request additional continuances or extensions.
Okay. Is this going to spur potentially some type of a policy agenda item on these kinds of things?
This is Jessica Guerra for the record. The short answer is no.
Okay, I like short answers. Okay, all right, looking for a motion.
Chair, just 1 minute. Liz had something to chime in on it.
Go ahead. Oh, I'm
This-
sorry.
It's retroactive because it had been expired for a period. So he's asking for 6 months from August 2nd, which brings it to February 2nd.
February 2nd, says we're
Yeah.
we're extended to
So
February.
it's not a
14th.
long extension. Just wanted to point that out.
Okay. Commissioners, motion.
Chair, I'll motion to item number 92 on the agenda.
And will that include a proviso that the applicant is to have no additional extensions on their compliance period unless they provide substantial information to substantiate that request?
Agreed. I didn't want to say substantiate.
Yeah, you got it. Double it up. Good job. Sorry. So that would be your motion?
That will be my motion.
I'll second that, Mr. Chairman.
Okay, so we have a motion by Teddy, second by Zoka. All those in favor, please signify by saying aye.
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 Motion carries unanimously. Commissioners, that takes us now to item number 94, which is docket number 23-01003. It's the expired compliance of the sale and transfer of dependable tow. We have, and that's CPCN 7326. We have someone here. Would you like to come up, man? Come on up. Hold on just a second. So Ms. Babcock, take us into this, and then I will let this young lady introduce herself and we can go from there.
All right, this is a sale and transfer application for dependable tow that was granted and has been expired on the compliance period. Normally, if that happens and we don't get any responses to emails and phone calls, et cetera, then we just move to dismiss the application. This is something that's already occurred, so we cannot just dismiss it. So we're asking therefore instead for an order to show cause as to why we should not revoke their certificates.
Okay? Tell me who you are.
My name is Melissa Woldridge on behalf of Dependable Tow. So look,
Hold on. Spell your last name for the record.
Wooldridge.
Woldridge?
Wooldridge.
Woldridge.
Yeah.
Thank you, Ms.
course.
Woldridge. All right, go ahead.
So I believe we were working with Howard Woods to complete everything. And as far as we know, we thought it was all completed. And then we had emailed him again and his emails were kicking back. So looks like we emailed Desiree Main, emailed us and we replied to her email. So we would like to continue to do what we need to do. So we're just trying to figure out who the next person is to talk to complete this.
Commissioners?
I'd like to hear from Ms. Babcock, Mr. Chairman.
Ms.
Well,
Babcock?
if they're willing to move forward with it, I mean, I'd be fine with that, but we weren't able to get any responses and I sent a few emails myself. But if they're willing to move forward with it, I would say, okay. But I would like this to be tabled though, so that if we don't have any action over the next 30 days, we can bring it back.
Right?
Okay.
Do you understand that?
Yeah, so we need to, I'm
No. Okay. Let me just explain what Ms. Babcock just said.
Okay.
What she's asking is that this is not going to go away. We're just going to table it.
Okay,
And what that means is that we're giving you an opportunity. We're giving you 30 days to take action on it. If you don't take any action within that 30-day time period, it's going to come back to us and then we'll act on it at that time.
okay. Sounds good to me.
Okay?
Yep.
All right. So commissioners, questions?
Chair, I have one. Ms. Woolridge, who is the point of contact for staff? Because it appears that they tried to reach out and they were pretty much told whoever they were dealing with was no longer there and no one knew exactly what any of this was about. So who will staff be dealing with?
It would be Inderjit Ram,
Okay,
also known as Mike.
all right, thank you. And it looks like they had his address, so I imagine they probably have contact information. We just want a little clarity for staff. Thank you.
Of course.
Would you like me to have her fill out a comment card with some information on it, Ms. Babcock, that I can give to Mr. Sigstad to get to you to make sure that we have some contact information that can be passed on to Ms. Main?
Well, we do have contact information for this, Mr. Ram. I've spoken with him in the past. I'll reach out to him again, but again, if we don't get any action moving forward, I'll just bring this back to
Okay.
the net agenda.
So I'm going to have her fill out a card so that we do have a phone number and another piece of contact information in the meantime. But I'm looking for a motion to table this item. Well, actually, do we even need a motion, Ms. Kerr?
Yes.
Hey, looking for a motion to table the item until next month.
Mr. Chairman,
Well,
I-
no, I'm sorry. Go ahead, Mr. Zoka.
my apologies. Chairman, I move that we table agenda item 94 as noticed in the agenda.
So
I'll second.
Forgive me. So, Mr. Teddy, before you second that, what I'd like to do is table, should we add some language, commissioners, that says that if there's no, because just tabling it until next month brings it back automatically. If we put language in the motion that says that staff is able to get this completed, keep it moving, then there's no reason to bring it back.
I second those modifications and incorporate them into the motion I made, Mr. Chairman, along with the fact that the item would need to be brought back if those conditions are not met by the next meeting, which is January 15th. So that'd be my motion, Mr. Chairman.
And I
Okay.
will second the amended motion.
Okay, so we have a motion by Commissioner Zoka, second by Commissioner Teddy. Ms. Woodridge, do you understand?
Yes, so we have until January 15th
Yes.
to get everything taken care of.
Well, we want you to be in contact with staff in the interim. If we don't have things substantially moving by that time, we're going to bring it back and then act on it.
Okay.
Okay? All right, all those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. Do me a favor, fill that out with
Okay.
phone number and stuff. Commissioners, that takes us now to items 95 and 96. So 95, it looks, I had a note that was pursuant to number 83, which we now have passed and ratified, which was the modified tow tariff. So Ms. Babcock, go ahead and take us into those next two items, please.
Item 95, this was bifurcated last time. You're right, because this carrier had not done that 30% increase from 2024. And he also wanted to do the CPI. So we needed to find out how to handle the CPI. But he did get the 30% the last time. So I don't know that he would be eligible for this time, but is eligible for that, for the CPI. Or he has to wait for the 2025 one.
Okay,
But whichever one, if either, we'll see that he gets.
all right. Do we need to take these individually, Ms. Babcock, or can we block them?
But the tariffs,
Yes, the financial rates and tariffs, 95 and 96.
you can block them.
Okay. Commissioners, any questions?
I have a question on 95.
Go ahead.
So they are asking for the CPI.
That is correct. He originally filed, and we split it in two because he asked for the 30% rate from 2024 that was granted to all carriers.
But
So he got that at the last one.
I believe our motion previously would kind of cancel out the CPI increase and he wouldn't be eligible for it. Right?
Right, until 2025.
Correct.
Right.
So until January of 2026,
2026, right,
then
Or-
they can claim a 2025 CPI.
that's right.
So would you have him file another tariff modification to do that?
In January of 26 to reference a
Yes.
25 rate.
Okay.
So
Are
I
we-
don't.
I'm sorry. Go ahead, Mr. Teddy. I apologize.
Go ahead, what was your question?
No, I thought it was the previous year. So right now he qualifies for the 24 CPI because it's the previous year. And in January of 26, it'll be the 25 CPI.
It's only on an annual basis.
But yeah, the motion excluded, and I don't know how we can go back to that, but any carrier that amended in 2024 was going to be prohibited based on the motion from filing for the CPI.
But he filed it now in 25. So he didn't file it.
In
And he may have filed other things. I'll have to look. But for 2024, he did not take that. He took that now in 2025. So he's not eligible for the 2025.
Okay,
He won't be eligible again until 2026.
6 for the CPI.
January.
Correct.
Right.
And Administrative Attorney and the commissioners can correct me if I'm wrong. If he takes a CPI today, eligible to ask for another CPI until December of 2026.
For-
He can't come back January 2026 and say, I want a CPI because it's on an annual basis. They have to wait a whole year to ask for another one. I just wanted to make sure because you might have meant January 2027, but I thought I heard you say if he takes it now, then he can come back in January 1st.
No. It's always the previous year. So what I heard was that, in January 26, he gets the 25 rate.
As long as it's been a full year since he's had a modification for a CPI. Meaning if he took a CPI modification in April of 2025, he can't come and ask for another CPI modification until April of 2026.
Right, because it's the previous year.
Correct.
So he can,
But if they filed anything in 2020, which I don't know, we don't know right now, whether or not anything was filed.
You can see how this is going to be a nightmare for staff.
Yes, oh, yeah, absolutely.
Oh, dear.
maybe.
So do we,
Back to make sure
I-
he hasn't done it.
Yeah, so Chair, for me, I would be uncomfortable just for purposes of discussion moving forward on this. I would rather have staff just conduct a little bit of research to check what was done tariff wise in 2024.
would you be amenable to making a motion that allows them to move forward if staff finds that nothing was done? Does that make sense to you? So in other words, if staff
I-
investigates and
Hold on, I'm trying to,
I am, I just don't know if they can take action, and we'd have to check with staff if they can take action on their own or whether or not they'd have to come before us to move that along.
I see Mr. Brown coming up. No, I guess what I'm saying is if we give them the authority to take action, so long as nothing occurred previously, if something did occur, then basically that's what triggers the non-action.
Did get the tariff modification in November 12th, 2025, but that was on the.
I'm sorry, Chair, Supervisor Brown had pulled up some of the tariff information.
So the tariff that they had stamped recently was November 12th of 2025, which came after the November 6th agenda where we split the tariff. So I don't, and
But then a
unfortunately,
no CPI increase, that one had no CPI increase.
Right,
We
that
have-
was
We
the
had
30%.
released the CPI.
It's not realistic, yeah.
Correct,
But it was an increase.
but it was an increase.
It was an increase.
They had a tariff modification November 12th of 2025.
So as I see it, we have to go back and look at what happened in 2024, because I don't know if
Yeah.
it did any increases or anything. We have to look at 2024, and then he may be eligible for that retroactive one. So we're not penalizing him from that. But he took this 30%, 2025.
So he can't take 2025.
So he
CPI.
can't, right, he has to wait. And because it was on all rates, he has to wait until 2025.
Okay.
So I have for the record, Jessica Guerra, and forgive me, I'm processing what's happening. So if I get lost along the way, let me know. The question I have is, if this application is approved, are they therefore then prohibited or denied the benefit that was voted on earlier this morning of receiving the year 2024? Does it impact it at all?
They're not denied it, but they have to be qualified for it. Say, because you can't, you can only take this once a year.
So
So we would essentially agree to this without knowing whether or not they qualified, is what she's saying. We have to look back in the tariff history. to
Or approve
see-
it conditionally, assuming that,
Right, if we,
Yeah.
I guess if we sell them.
right, so
That's-
I guess, the
that-
question- so the question would then be, like, the clarifying question is, would this approval somehow deprive them of that benefit?
No.
No? Okay,
Because
No, but it could entitle them to a benefit, unless we exclude them, it could entitle them to a benefit they may not be owed.
right.
right.
The way right, the administrative attorney only, it's not going to deny them of anything because it seems like it's a conditional approval provided they had not taken anything in 2024. So it'll
Okay.
give them the benefit.
Right.
It won't take away anything they're entitled to.
Okay,
It's
Right.
just, it's kind of a rehash of what happened in 2024 to see if they're entitled. If not, they just stay where they are.
okay,
And they're not, and it's a non-entitlement to it. It's not a deprivation. Does that make sense?
that's kind of where my confusion was.
So it's, yeah, we just need a motion that's conditional, correct?
Yes, I think that's where we're at, Sherry, yes.
Yeah, yeah.
So, I guess I can make the motion. My motion would be to approve, agenda item number 95, on the condition.
No,
I'm
Are we
sorry.
on 96?
95.
95,
we're on
they're the
95.
toe. They're the toe.
Okay, my bad.
So the condition would, with the condition that they would be, they would actually qualify for the rate increase in accordance with, the prior agenda item, was it
83.
83.
Second,
Okay. Ms. Babcock, do you understand the motion?
I do.
Perfect. All right, we have a motion by Commissioner Teddy, second by Commissioner Zoka. Is there any public comment on this item?
No one is coming forward in Las Vegas.
There are no hands raised online.
Okay, we have a motion and a second. All those in favor, please signify by saying aye.
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 Motion carries unanimously. 95, now 96. I apologize. I'm blind in one eye and can't see out of the other. Docket number 25-11013. Application for Bell Chauffeured Services. Ms. Babcock.
Yes, this was for a temporary rate increase based on a certain time period for the F1 event. So that has, it was granted, it has already expired, so we don't need to send an order out for it. However, it was done on a very short term. Ms. Rushton is not here currently. She was here this morning, talked to me about it and said that she thought we should look at setting parameters date-wise when it's acceptable, because some of them are submitted on such short term. Which I said, I thought we were going in that direction anyway, but
Do
she's just
do we
not here.
need, oh, no, I'm sorry, Ms. Babcock. Do we need any type of retroactive approval on this?
Well, I mean, it was approved by the one, I believe it was Commissioner Zoka.
Where is he? No, I'm just kidding.
And so I don't know if you want to confirm that. But it has expired.
And Chairman, Administrative Attorney Yoni Wilburn, just with regards to what Ms. Babcock said, it would not be appropriate for Kimberly to bring up that discussion at this, because we're not styled for that discussion. We're only styled to approve or not approve the tariff. So even though she's here, not here, I would advise we do not get into the discussion about setting time limits because that is not agendized.
Oh, no. And I didn't take that at all, but thank you for that, Ms. Wilburn. I appreciate that. No, I was just looking specifically at what was before us under docket number 25-11013. My question was, do we need to grant them any type of retroactive approval? Because I guess I don't really understand, since this is passed, this is it's already taken place. What does staff need from us?
Chairman, I think just because it's a tariff Administrative Attorney Oneat Wilburn for the record, because it is a tariff modification and all of those do come before the authority, I think we just need to give a quick vote on retroactive approval, even though they were allowed to do it. This happens a lot with our special events, and a lot of times they can't make the agenda, but that's for a further discussion. So I think we should do a retroactive approval on it, just so we have the full authority's approval on it.
Okay, that was exactly my question, was retroactive approval. Okay, commissioners, looking for a motion. Mr. Zoka.
Mr. Chairman, I would move that we approve agenda item 96 as noticed in the agenda.
I'll second that, Chair.
Okay, a motion by Zoka, second by Teddy. Do we have any public comment on this item?
No one here in Las Vegas is coming forward.
Okay, and I see no one's hand raised online. All those in favor, please signify by saying aye.
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 Motion carries unanimously. I'm sorry, go ahead, Ms. Babcock.
Does that mean we should put a discussion item on for deadlines for these? Okay,
I didn't tell you that. I was just coming to tell you that for January 15th.
Yep.
The answer is yes, Ms. Babcock.
thank you.
So now we are at request for temporary discontinuances. I have it as item number 97 through 102. And so the way that I've got this is that we could take it as a block unless a party on the matter requests an item to be pulled from consideration.
And Chairman, Administrative Attorney Oneat Wilburn, I've noticed this throughout the agenda and I just wanted to make a comment. The numbers are off a little bit. The authority is doing it correctly. They're taking the correct numbers under the correct headings. However, just the one sentence that says, please note that item so-and-so, it's just off by a number, but they're being done correctly and every item has been addressed.
Oh, and I appreciate that. And Ms. Babcock and I saw that the agenda had already been posted and that there was a typographical error. It was my bad this morning for not bringing that to notice. But you are correct. But you'll note that I have listed the correct agenda items. So we did 96 previously. We are now on 97, and that goes through 102, not 103. So is there anyone wishing to speak on item 97, docket number 25-10026?
No one here in Las Vegas is coming forward.
Anyone
Okay.
online?
No hands raised online.
Docket number, this is item number 98, docket number 25-11009.
No one in Las Vegas is coming forward.
There are no hands raised online.
Item number 99, docket number 25-11021.
No one in Las Vegas.
There are no hands raised online.
Item number 100, docket number 25-11024.
No one here in Las Vegas.
No hands raised online.
Item number 101, docket number 25-11025.
No one coming forward in Las Vegas.
No hands raised online.
And our final docket, item number 102, docket number 25-11028.
No one is coming forward in Las Vegas.
There are no hands
Right.
raised online.
Perfect. Thank you so much, staff. So, commissioners, it appears as if we can take items 97 through 102 in a block.
Chair, I'll motion to approve items number 97 through 102 as agendized.
Second.
So I have a motion by Teddy, second by Zoka. I will ask one more time, is there any public comment on any of these items?
No one in Las Vegas.
There are no hands raised online.
All those in favor, please signify by saying aye.
Aye. Aye.
Motion carries unanimously. Commissioners, that takes us to items number 103 through 105, requests to extend temporary discontinuances. Ms. Babcock.
Yes, item 103. Let me say docket number 2407-027 is a request for an additional 6 months due to illness. And staff supports that one. Item 104, docket 2504-022 is also a request for an extension. I have to pull up the background page here. And they are requesting based on insurance, looking for better insurance rates, which we have a lot of these discontinuances because of insurance rates. And 105 docket 2504-030, another request for extension is based on it just says family. This is
Commissioners,
their,
any- I'm
His
sorry, go ahead,
reason-
Ms. Babcock.
I'm sorry. His reason stated as family, doesn't say what about his family, just family. And he has, his docket is from April of this year. This would be his first extension. So the first 6 months, this would be his second one.
And is staff supportive of these?
Staff doesn't really take too much offense until it's over a year.
Okay. Commissioners,
Mr. Chairman, I would move that we approve agenda items 103, 104, and 105 as noticed on the agenda.
I'll second those, Chair.
we have a motion by Zoka, second by Teddy for 103, 104, 105. Was there any public comment on any of these items?
No one here in Las Vegas.
There are no hands raised online.
All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. That takes us now to expired temporary discontinuances, items 106 through 110. Ms. Babcock.
Item 106, docket 2408-017 is requesting. They have been out since August of 2024, and their reason is family matters out of the country. It's over that year, so staff is not in support and would ask for the order to show cause.
Okay. Let me ask this. Is there anyone online or in Las Vegas on items 106, 107, 108, 109, or 110?
No one is coming forward in Las Vegas.
There are no hands raised online.
All right, well, these are takings essentially. Would you like us, legal, would you like us to take these individually? And since we have no one who's coming forward, we technically can take them in a block, but we certainly can take them individually.
This is Jessica Guerra. I just want to note that the expired temporary discontinuance section does not have that one sentence that says, please note these may be voted in a block. However, it doesn't necessarily prohibit the commission from voting in a block, so long as the commission notes like we're going to vote for these in a block. If I understand what each docket number is requesting, it's requesting to issue an order to show cause, not that they're granting an order to show cause or denying one. So long as the language of the motion is clear that these are being voted in a block and what the intention is for each one, it should be sufficient.
And I think, and I'm sorry, go ahead, Ms. Kara.
And just to clarify, so long as everyone's agreeing with each point being like, we're going to approve these, we're passing all of these after voting whether or not they're going to be in a block. If there's something that, say for example, like 109, if there's an issue that the commission has, maybe you vote that out separately.
Okay,
And Chairman Administrative Attorney O'Neill Wilburn, I concur, just since this is moving it to an order to show cause, not actually conducting order to show cause hearing, they can be taken in a block.
okay. Okay. So again, I'll ask, is there anyone wishing to speak on items 106, 107, 108, 109, or 110?
No one here in Las Vegas.
There are no hands raised online, Chair.
Okay, and just for a good clean record, item 106 is docket number 24-08017. That is the temporary discontinuance of high roller transportation. Docket, item number 107 rather, docket number 24-08027 is Cooper Holdings and Las Vegas Knights Transportation. Item number 108 is docket number 24-09002. That is 2020 towing. Item number 109, docket number 25-01039. That is Olmsted towing. And item number 110, docket number 25-02007 is GR Holdings GRG towing. Commissioners looking for a motion.
Mr. Chairman, I would move that relative to agenda items 106, 107, 108, 109, and 110, as noticed in the agenda, we follow staff's recommendation and issue an order to show cause as to why a CPCN should not be revoked.
I will second that motion, Chair.
Okay, we have a motion by Zoka, second by Teddy. We have asked for public comment in numerous ways. We have outlined each agenda item and docket number. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. That takes us now to item number 112, as item number 111 was removed. Item number 112 is, these are petitions for reconsideration. Docket number 25-11003, petition for reconsideration for Yunel Diaz.
Chairman, I don't see anybody coming forward in Las Vegas. Administrative Attorney O'Neill Wilburn.
Thank you. Anyone online?
There are no hands raised online, Chair.
Okay, commissioners?
Mr. Chairman, since they're not here, I would move to deny the petition for reconsideration. So my motion would be to deny agenda item 112, docket number 25-11003, as noticed in the agenda.
I would second that, Chair.
I have a motion by Zoka, second by Teddy. Let me ask again for public comment. Do we have any public comment? Again, this is docket number 25-11003, a petition for reconsideration for permit number T32, Yunel Brunette Diaz.
No one is coming forward in Las Vegas.
There are no hands raised.
Okay. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. That takes us to item number 113, rather. Docket number 25-11004, petition for reconsideration for the decision of impound for impound 25567. That looks like a citation number, not an impound, for Kiros area.
No one is coming forward in Las Vegas.
Mr. Chairman, I apologize for the interruption. Let me also just state that I was the DAG involved in this when I was with the Attorney General's office. So based on that, I'm going to recuse myself from item 113. Thank you, Mr. Chairman.
Thank you. Okay, is there anyone wishing to speak on this item?
No one in Las Vegas.
There are
Well,
no
I
hands-
took, I'm sorry, Mr. King, go ahead.
There are no hands raised online.
I pulled this item. I took the time to read it. I think that The impound and the citations were proper, so personally, I'm not willing to support a petition for reconsideration. That would be my motion.
I'll second your motion, Chair.
Thank you. Motion by Hartung, second by Teddy. Again, any public comment on item number 113, docket number 25-11004?
No one in Las Vegas.
There are no hands raised online.
Thank you. All those in favor, please signify by saying aye. Aye. Motion carries unanimously with Mr. Zoka abstaining. That takes us now to item number 114, docket number 25-11011, petition for reconsideration for permit number T50 for Ebony Tinner.
Ebony Tinner is here on the phone.
Great. Welcome, Ms. Tinner. So, commissioners, let's take care of this first. Do we want to grant the petition for reconsideration? Would you like to hear from Ms. Tinner as to why she wants this? What's the desire of the board?
Chairman, Administrative Attorney O'Neill Wilburn, give me just 1 minute to consult down here or to look at this, please. Sorry.
Yeah, no, and that's okay. And if we do grant the petition for reconsideration, we can certainly hear this permit. But commissioners, then we will ask if she would like a closed session under NRS 241-.030, which I will take us through. So the question is, the first question is do we want to grant the petition for reconsideration? And let me do this. Let me ask Ms. Tinner, go ahead. So why would you like us to hear this item? What's the reasoning?
If I'm honest, sir, I'm totally confused on why I'm even here, to be honest. I held this permit a little bit over a year and was never questioned about it. So I don't even know how I'm here, to be honest.
Okay, well, let me explain. Your background check came back and there are some issues that we would need to discuss that are potentially disqualifying. So again, the first question, commissioners, is are we going to grant the petition for reconsideration? And then if so, then we will offer her to have a closed session so that we can discuss these matters.
And Chairman, Administrative Attorney O'Neill Wilburn, just for clarification for Ms. Tinner, I know she says she held the permit for a year. That's a temporary permit. And the vote by the authority was to give her her full permit. So that's why you're here, Ms. Tinner, because it was a temporary permit until it was put on the agenda to vote on by the commission. You understand?
Because there were extenuating circumstances in her background.
Okay.
So, commissioners.
Chair, I would make a motion to grant the petition for reconsideration.
I'll second that motion. Okay. So we have a motion by Teddy, second by Hartung to grant the petition for reconsideration. Is there anyone who has public comment on this?
No one is coming forward in Las Vegas.
There are no hands raised online.
Okay, we have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Aye. Mr. Zoka, are you an aye or a nay? I'm sorry, I didn't hear.
I'm a no, Chairman.
You're a no. Okay. Well, motion carries 2-1. So now, Ms. Tinner, you have the opportunity to have a closed session to discuss this. And so If you would like that, then what we'll do is we'll clear the room down in Las Vegas. We'll clear the room up here in Reno, and we'll clear the chat room, and then we can discuss your background that came back.
Yeah, we can have a close.
Okay? So, hold on just a second here. Let me read this. We
Miss-
will now, I'm sorry, go
Sarah-
ahead, Miss. Go ahead.
Okay. So the motion would be to hold a closed session pursuant to NRS 241.030 subsection 1A to consider the character, alleged misconduct, professional competence, or physical or mental health of Miss Ebony Tenner.
Okay, that is my motion.
I'll second that motion, sure.
All those in favor?
Aye.
Aye. Okay, motion carries unanimously. So I'm gonna need you to step out. We'll let you know.
Commissioners, if I may, just address the people who are on the team's meeting.
Yeah, go ahead, Mr. King, just because I know that sometimes it's hard for them to get back in, so go ahead.
Thank you. So there are some individuals for whom we cannot assign them to a closed room on the team's call, and we may have to kick you out of the meeting entirely. Please request to join back, and we will let you back in the call.
Yes.
When we're back.
Executive session's good.
And I'm gonna go ahead and do that.
Okay, you tell me when we're ready, Mr. King, and then tell me when we're ready. The Las Vegas office, when it's ready. The Reno office is now clear.
Las Vegas office is clear.
Okay? We are now in closed session.
So motion to reopen the closed session pursuant to NRS 241.030 after considering the character, alleged misconduct, professional competence, or physical and mental health of Miss Ebony Tenner.
That's my motion.
Second?
All those in favor?
Aye.
Aye.
Aye. Motion carries unanimously. We are back in session. So commissioners, again, I am willing to support this request. I think she's on probation. She's working. She's been working for a year. I personally don't want to take away her ability to earn a living. That's my motion to approve.
Mr. Chairman, I would not be in favor of this if she worked in the limo industry, because the potential connection between the limo business and the type of issue that we're looking at here without identifying what the issue was. But because she works for GMT, I am more in favor of supporting it. But I do want to hear from my
I'm
fellow.
sorry. I apologize. Go ahead.
I would be willing to support, to piggyback on Commissioner Zelka's things. Obviously, the connection to limos and nightlife would be concerning to me. I would be willing to support the permit, providing that we had some sort of regular check-ins with her supervision. I
What
don't
would
know.
those look like? What would those look like, Commissioner? Because I mean, without without doing background checks, I mean, these last for, by NRS 706-462, they last for 3 years. So I don't know. I mean, I guess what we can do is have a check-in with the probation officer. We do have a letter from the probation officer that says that, she's been in compliance with the terms and conditions.
It's just so early in the supervision period is what concerns me. So, I mean,
So if I can say this, that I'm on the lowest of the lowest of probation. I do not check in with my probation officer. I don't do drug tests. I don't do anything. I'm actually up to file a motion to get released from probation because I have never been in any trouble. I have never failed a drug test. I have never had to be questioned about my probation or why I'm on probation. So I'm actually in the process of filing the motion to be released off probation due to me just sitting on probation and not being supervised.
So commissioners, there's a motion on the table. I'll restate that motion. I'll make a motion that we approve the driver's permit. Okay, it appears motion fails for lack of a second.
Mr. Chairman, if I might try something, could we bring this back in a year,
6 months.
in 6 months,
See if her petition goes through.
and then reconsider? I mean, she's already been granted her petition reconsideration. At this point, her temporary permit allows her to drive. And in 6 months, we would give this an additional consideration.
Yeah, with her challenge
With
to
her-
her probation.
With her
Yeah.
challenge to probation. So my motion would be that we table this for 6 months to the general session that follows immediately after that 6 month period.
Yep, and she can continue driving for.
In the interim,
Yeah,
she
in
can
the
continue
interim.
driving in the interim with her temporary permit that has already been issued by the NTA. So she can continue to work.
I would,
for now.
I would second that motion, Chair.
Okay. So how is staff or how are we going to follow up on this? We have a motion by Zoka, second by Teddy. Under discussion, how are we going to follow up on this?
Just put it back on the agenda in 6 months.
Chairman, we have, I don't know if we want to do it. We have an agenda on May 21st. I don't know if we want to shoot it over to that.
Yes.
Mhm.
I'll modify my motion that this be continued to the May 21st agenda, and she can continue to work her temporary work permit.
And I
Why
will
don't we?
second.
Okay, I'm okay. Again, I have a motion and a second under modified. Can we push it to give her 6 months? Because technically, I mean, we're in the holiday season and we all know how difficult it is to get anything through the legal system during the holidays.
Yeah,
Can we just
so
move it to June?
Chairman,
I'll withdraw my motion and then I'll let Commissioner Teddy make the motion.
Chair, that motion, so we're gonna move it to the July 9th hearing. So we're not gonna, basically take any further action. We'll trail it over to July 9. And then we'll revisit the status of it pending her challenge to probation.
I
I'll
would be
second.
supportive. Okay, so we have a motion by Teddy, second by Zoka. Do we have any public comment?
No one here in Las Vegas is coming forward.
Okay, Ms. Tanner, do you understand the motion that's on the table?
Yes, if I understand correctly, you guys are going to wait to see what happened if they grant my release of probation, and I will return back July the 9th to get
Yes, ma'am.
give you guys the update.
Yes, ma'am. That's exactly correct. Well done.
Ms.
Okay, we
Tanner-
have- I'm sorry, go ahead, Ms. Wilburn.
Administrative Attorney Unit Wilburn. So Ms. Tinner, you can continue to drive on your temporary permit until then. Do you understand that?
I do.
Okay.
Okay. We have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. Let me open the door back up here because I have locked Mr. Jocelyn out unintentionally. Commissioners, we are now on item number 115, docket number 25-11012, petition for reconsideration for the decision of the permit T25 for Mr. Isaac Jocelyn. And Mr. Jocelyn is here present in Reno. So let me just get myself organized, Mr. Jocelyn. Hold on a second here.
Discussion. You guys want to?
Okay, so let me explain to you what you have the option to do here. We need to discuss your background check. We can go into a closed session where we discuss that in private, same as what we've just done. And it'll give you an opportunity to have a conversation with the commissioners about what the background check returned, or we can do it in an open session. It is your choice.
Closed session.
Closed session. Okay. Ms. Guerra, would you take us through that, please?
Sure. So the motion pursuant to NRS 241.030 is to have a closed session to consider the character, alleged misconduct, professional competence, or physical or mental health of Mr. Isaac Jocelyn.
That's my motion.
Second.
I have a motion by Hartung, second by Zoka. All those in favor?
Aye.
Aye.
Aye. Okay, we're going to move into a closed session. Mr. King, tell me when everyone is out.
And I just want to give people online the same warning as last time. You might have to be kicked out of the call, in which case you can go ahead and reapply to join, like you enter back in. We are now in closed session.
The motion is pursuant to NRS 241.030 is to come out of closed session where the commission has considered the character, alleged misconduct, professional competence, or physical or mental health of Mr. Isaac Jocelyn.
That is my motion. Do I have a second? Okay, I have a motion by Hartung, second by Zoka. All those in favor, please signify by saying aye.
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 We are back in session. Motion carries unanimously. I'm going to give you back this so that you have that to put in your records because we don't need it any longer. Commissioners, what would we like to, so let's do this first. Let's vote on the petition for reconsideration. I'll move that we reconsider the decision for permit number T25 for Mr. Isaac Jocelyn.
Second.
Motion by Hartung, second by Zoka. Is there any public comment?
No one here in Las Vegas.
And I think everyone's back online. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. Commissioners, what would we like to do on this?
I think I would be supportive of allowing him to have a driver's permit, Mr. Chairman.
Okay, looking for a motion.
Okay, motion to approve driving permit for Isaac Jocelyn.
And I'll second the motion.
And that is docket number 25-11012, permit number T25 for Mr. Jocelyn. Is that correct, Mr. Zoka?
Yes, it is, Mr. Chairman.
Just want to make sure that that's on the record. So we have a motion by Zoka, second by Teddy. All those in favor, please say, well, actually, let me ask, is there any public comment?
No one here in Las Vegas.
There are no hands raised online, Joe.
All those in favor, please signify by saying aye.
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 Motion carries unanimously. Mr.
All right,
Johnson,
thank you. So I can just go
you
back
can go.
back to
Go to
work.
work.
All right, thanks so much.
You'll get your permit.
Every day.
Thank you, sir. Okay. Commissioners, that takes us to item number 116 through 119, dockets, voluntary cancellations. Ms. Babcock.
Yes, sir. I think they speak for themselves. That's items number 116, docket 25-11016 for RS Enterprises doing business as 365 Towing. Item 117, docket 25-11019 for T1 Transportation, and item 118 for T1 Transportation as well. This carrier has given up these certificates, CPCN 2115 and 2016, in order to be approved as a contract carrier. And docket item number 119, docket 25-11026 Santa Fe Towing. And as I said, these are voluntary cancellations. Staff supports them.
Commissioners, any questions?
None for me, Chair. None for me, Chair.
Is there anyone online wishing to speak on this item under public comment?
There are no hands raised on mine, Chair.
Anyone in Las Vegas?
No one in Las Vegas.
Looking for a motion?
Chair, I'll make the motion to approve items number 116 through 119.
Second.
Motion by Teddy, second by Zoka. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. That takes us now to item number 120, docket number 25-11031, the formal complaint of the decision for the complaint investigation number I-2502-048 for Mr. Richard Eaton. Mr. Eaton, do we have you online?
Mr. Eaton is sitting in Las Vegas, Chairman.
I beg your pardon. Sorry. Welcome, sir.
Good morning, or good afternoon now. It's been a while.
And Commissioners, Administrative Attorney Oneat Wilburn, I know I've said this a couple of times, and these are getting more regular on our agenda. The decision the commission, the authority is making today is whether this warrants a further hearing or if the commission is in agreement with the investigative report. So the hearing is not being conducted today. And I did tell Mr. Eaton that in emails, and he does understand.
I would also ask Mr. Chairman that I see Mr. Supervisor Messinger Brown is in the room. If you could approach the desk as well, just in case we have any questions. I saw
Sure.
the
No,
email.
I'd like that. No, thank you, Mr. Zoka.
Thank you so much.
Go
Thank
ahead,
you.
Mr. Eaton. Tell us,
I just wanted to thank the authority for having me here today. I could have appeared via telephone or teleconference, but I wanted to be here in person. This matter is very important to me. I feel like the limo driver took advantage of me because of my intoxication, and he should be held accountable for his actions. The facts are, I was given a ride from the Bellagio to Resorts World. It's about a mile and a half, and the limo driver charged me $1,800 for the 1.5 mile ride, which is unconscionable under any standard. I tried to get a itemized receipt. I've tried to have the driver justify the charges. I received nothing. The only response I get for him is he threatened me with a harassment lawsuit when I tried to request an itemized receipt and anything to substantiate the charge. I tried to negotiate with him, accept a lesser amount in order to put the matter to an end. He threatened me with an extortion lawsuit. The driver has been uncooperative. Not until 9 months after I filed a complaint with this body that I found out that he was employed by a company called BLS company. He never informed BLS of my complaint. Is my understanding that BLS has a responsibility to report to the the authority within 2 days any complaints against the driver. The driver never told BLS. The only reason BLS found out about this was because the authority contacted BLS. He hid the situation from BLS. BLS has been uncooperative. The only thing I received from BLS was a trip receipt, and the trip receipt was for $67.98. That's the only thing I received. I've repeatedly requested a receipt to substantiate the charge. I've repeatedly asked for just any itemized receipt. I received nothing. These are red flags. And this matter happened 1.5 years ago, and I'm pursuing this matter, and I'm going to pursue it to the fullest because the driver should not be able to use a license provided by this body to take advantage of an intoxicated passenger. And the reason this is so upsetting and unconscionable is because I was heavily intoxicated. I don't remember the incident. It was not until about a week after I received my credit card that I received the $1,800 charge. And since then, I've been trying to get any information I can in order to substantiate the charge. And all my research indicates that this was unconscionable. The driver took advantage of a vulnerable and incapacitated passenger. And, he used my credit card under license provided by this authority to take that money from me. I was able to get an allegation that I urinated in the vehicle. And I've received no documentation or pictures or substantiation or anything in a year and a half to substantiate that allegation. Even if that allegation were true, the cleaning fee, I believe, is set by this body, or there is a reasonable and customary fee in Las Vegas, and it's between, I believe, $50 and about $500. So even if it is as the driver alleges, which he's provided no proof and has been extremely uncooperative. I asked him, if he would consider, paying me some of my money back, and then he threatened me to charge me even more. It is my understanding under the Nevada Administrative Code that he has a duty of fair dealing with passengers. He also has a duty of integrity. And he also has a duty to act appropriately because he is held in a position of trust. And I believe he violated that trust. I cannot think of any circumstance where an $1,800 charge would be justified. To be clear, the charge was broken up into two charges. There was a $1,500 charge and a $300 gratuity. I initially spoke to him. I spoke to him on the phone once, and he said he had to talk to his company and that he would call me back. He never did, and it's been a year and a half. Initially, he said the $300 was a mandatory gratuity. And if you calculate the percentage, $1,500 charge with a gratuity is a 20% gratuity, which he initially said was mandatory. He later told BLS that the gratuity was voluntary, which is absolutely absurd, because if I was so intoxicated that, he's claiming I urinated on myself, how am I supposed to calculate a 20% gratuity on a number that he conjured up, $1,500? If I was so intoxicated that I urinated on myself, I would be unable to, do percentage math and calculate gratuity, and for that matter, even contemplate a gratuity. So there's not only a problem with the charge, but also with the gratuity. So the fact that he told me it was a mandatory gratuity, which makes sense because it's a 20% gratuity that he added. The fact that he said I voluntarily gave it is absurd, because how am I supposed to calculate a gratuity of 20% on an amount that, he conjured up? And I urinated on myself, according to him.
Mr. Eaton, I'm gonna
Yes.
ask you to complete your thoughts real quickly here.
Yes, of course.
Go ahead.
Yes. So anyway, it's my contention that, he used this license in order to take advantage of an incapacitated passenger. He's in a position of trust. He has responsibilities under the NAC to deal with passengers in a fair and, in fair dealing. BLS has been uncooperative. And the driver has been uncooperative, which raises red flags. And more importantly, BLS only received $67.98. The driver retained $1,732.02 himself. That was he retained. It is absolutely ridiculous. That's why I'm appearing here today. He cannot take advantage of the general public, by a license provided by this body. There's no justifiable, reason for this. Cleaning fees are set and the fees are set. So $1,500 fee and a $300 gratuity is absolutely obscene. And the fact that they're round numbers calls into question, everything. So I'm questioning this body to have a hearing and, explain, to this body why he did not provide the requested information, why he threatened me, and why, he didn't tell BLS about this complaint. BLS has a responsibility to notify this body within 2 days of a
You've said that, Mr. Eaton, you've said that. So now you're repeating yourself and you're being redundant. So I'm gonna stop you just for a moment because I want to hear from Investigator Brown. So Investigator Brown, just outline for us real quickly, what are the statutes that we have authority over?
NRS and NAC 706, sir.
Thank you. Was there any violation by BLS in your investigation or the driver in your investigation of NAC or NRS 706?
No, sir.
Okay. So, commissioners, I mean, I've read through this and I see a lot of information here. I also see something that there's a letter from, it appears to be Resorts World, that there was one of the front serviceman attendants with Resorts World saw this occur. The way I see this, unfortunately, and this is just, I mean, we have to stay inside of our lanes. Commissioners, I see this as a civil matter, and I'm not trying to dodge any responsibility, but I don't know what we have under NRS 706 or NAC 706 that we can lean on unless Mr. Brown tells us that there was some violation of either one of those provisions, those chapters.
So, Mr. Chairman, I look at the NAC 706-3978 standard. It talks about probable cause. I think the police has looked at this. They haven't found probable cause for a criminal complaint, correct? I mean, we certainly have limo operators that are small and, they might be, some of them may be more willing to be, well, let me just not go there. Let me just say it this way. BLS, I think, is a pretty big company. They're a national company, I believe. And so I have certainly seen, as far as Las Vegas, larger corporations willing to fire an employee if in any way they felt that they violated their rules, whether it was a limo operator or a casino company. So the fact that BLS hasn't found any issues here either, that kind of goes a long way for me as well as the fact that our own investigator looked at it. So based on those, nobody that has looked at this, whether it was the employer, the police, or our investigators, have seen probable cause for this. Now, I don't want to prejudice the complainant here. I think they have a remedy potential remedy before the courts. So he can certainly file a small claims court, a complaint in a civil court, a claim against the driver, and he'll see how that goes. But as far as at this stage, I just don't think we probable cause standard under NAC 706-3978 to go any farther before this particular agency. Those would be my comments.
Mr. Teddy, any questions, and I'll follow up, or comments?
I mean, I do have some concerns. I mean, one of which is the driver is running around with some sort of independent credit card reader. That's concerning to me. I mean, I worry about charges going through personal transactions outside of company transactions. I mean, if there were some sort of cleaning fee assessed, obviously that should be included in a tariff, and it should be assessed by a company, not an independent driver, based on some random charge, not a tariff amount. With that aside, I don't think there's anything under our purview to do. I'll piggyback on Commissioner Zelka that I believe it's probably more in line with some sort of civil action against the driver. I believe in terms of the investigation that we did everything we could. law enforcement has looked at it. Obviously, if there was anything criminal, they would have clearly communicated that to us or addressed that on their own. Those would be my comments, Chair.
If it's okay with the committee, I'd like to make a comment.
Let that check.
Hold on just a second, Mr. Eaton, hold on. So, Mr. Brown, would you just summarize the investigation for us one more time, please?
Yes, sir. So I received the complaint, I reviewed it, I assigned it. It was assigned to myself to look into further. Upon review, I had to figure out and actually determine which company Mr. Agnall worked for. So I had to track that down myself by finding his driver permit. Learned it was BLS. I did reach out to BLS. There was a technological issue where they did not receive the complaint initially, which caused the delay in their response. They did request a extension of time to gather all their data, for which I granted, as we are allowed to do under NRS and NAC 706. Based upon the driver's statement, driver's witness statement, I went so far as going to Las Vegas Metropolitan Police's headquarters. I acquired a copy of the police report myself in order to see what their findings were in this. And there was a lot of conflicting information based upon everything that was turning about. They were
Tell us about that conflicting information, sir. I'm sorry. I want to hear a little bit about the conflicting information.
I would have to review my report further, but I do believe there was an issue with even where the transportation was supposed to be occurring. It appeared that either the pickup location or the drop-off location was not where it was supposed to be. The police reports redacted.
It's 23.
But there was a lot of conflicting information here that it didn't make. There was no supporting information that I could really glean anything from that made any sense. It would appear that the police report made by Mr. Eaton to Metro was in conflict with where he was picked up, where he was dropped off. In the drop-off location was one hotel. He was redirected to another hotel, or he redirected the driver to another hotel. There is a section of the NAC that says the driver will not intentionally try to redirect a customer wherever. So he was just following the passenger's request of dropping him off where he requested to. I'm not really sure why there was a redirection. I did review every statute and regulation regarding limo drivers, limo companies. I looked at different prohibited acts, everything just to try to, ensure I crossed all my T's and dotted all my I's. Because I do sympathize with Mr. Eaton that this is something that is quite out of the ordinary. But I also am reminded, being a lifelong resident of Las Vegas, that there's big winners here sometimes. And those big winners, they do take care of the service industry. And, you hear the stories all the time about large tips being left for certain people who provide exceptional service. And, it was also something that I had to consider in this instance where a limo driver providing good passenger transportation just happened to be the recipient of a large tip. So, a lot of things were taken into consideration here, but the main thing was making sure I made sure that no violations of NRS or NAC 706 occurred during the course of this investigation, for which I wasn't able to find any violations either on the side of the driver or the side of the company.
Good, and that's why I asked you specifically in the very beginning, not as legal advice, but you are very familiar being an enforcement officer, what statutes we live within the confines of. Did you take any pause? Commissioner Teddy brought up a very good point about a driver having his own credit card reader.
Yes, sir. That definitely did come into play. It does cause a bit of concern, but there is also a portion of a regulation that says that, the driver can be compensated by either the company or the passenger. And in this instance, the driver was compensated for the ride by the passenger. Now, whether the driver then passes along the carrier's tariff amount, which in this instance occurred also because there was the company that was charged for the use of their vehicle on their correct tariff amount of $67.98, I believe it was. So in that instance, no violations occurred when it came to uniform rates, and no violations of prohibited acts of limousine drivers occurred either because the driver was being compensated by the passenger and the driver ensured that the company was paid its tariff amount.
Okay. No, thank you so much for that. That was very thorough. Commissioners, any other questions or comments before I allow Mr. Eaton to make some closing comments, and then we'll make a motion?
None from me, Chair.
None from me, Chair.
Chairman, Administrative Attorney Rollburn, I will say that Supervisor Brown and I went back and forth numerous times on this because he did come to me for legal advice on the way to, and I looked at all the statutes as well, trying to see if we had missed anything. And my advice to him was to, and which he did, I believe, before putting this on the agenda, was to respond to Mr. Eaton that, we have looked at all the statute, we've considered all the evidence, but unfortunately, this is outside our purview of NAC and NRS 706, that he does have the remedy of going to the courts, small claims court, or however he sees fit. But unfortunately with us, our hands were tied as no NRS or NACs were broken based on the information we have.
Understood. Yeah, no, and that was my concern right out of the chute, were any provisions of NRS 706 or NAC 706 violated. So Mr. Eaton, go ahead. I'm going to give you several minutes to make any closing comments. You've kind of heard our deliberation. You understand the parameters with which we reside. So go ahead, sir.
The one thing I didn't hear was the urination in the vehicle. I heard gratuity. I heard tariff, but I didn't hear anything about urination in the vehicle. Was that still a complaint?
I would have to review my report.
Would you mind?
I haven't refreshed my memory on it.
Would you like to take a second to refresh your memory?
Well,
Chairman, I'm not quite sure why that's important.
Emails from you.
Well, it's important because the fee was $1,500.
And Chairman, this, again, it's, this is not a hearing, so cross-examining Supervisor Brown is not
No,
really.
I agree. I agree. I agree. Those, you can pose those questions to us, but Officer Brown is not obligated to answer those questions, but
I have a few comments if.
Go ahead.
Feel-
Go ahead with your comments. Go ahead.
From what I heard, the vehicle belongs to BLS. Is that correct?
So again, these are your comments. This is not a question, and we're not on trial here, sir.
I will assume the vehicle belongs to BLS. If there was damage to the vehicle, then BLS would require payment for that damage. There's no indication that there's been payment to BLS. I spoke with BLS counsel. BLS received $67.98, and that's the full extent of their payment. If there was damage to BLS vehicle, then they would charge me or they would charge the driver. And also the driver has been unwilling, as well as BLS, to provide any type of receipt. My reading of the NAC is it's required to provide a receipt with the information for the NAC so that the passenger can file a complaint if necessary. I mean, these are red flags, and also it seems inappropriate, and there must be some type of regulation that it doesn't allow for a driver to charge whatever they want. And that's aside from the gratuity. There was a $1,500 charge for transportation and alleged damage to the vehicle. But I've heard nothing about damage to the vehicle.
I'm scanning this report right now to assess that. I don't see anywhere that there's alleged damage to the vehicle. Commissioners, did any of you see that?
I mean, there was an allegation. I don't know if it was from the company side or the driver's justification. I'd have to go through it all, but there was an allegation that there was charges for urination in the vehicle. But again, I mean, that goes to my point, Chair, as to, charges need to be substantiated and they should be in the tariff. But if this is something the driver did on his own, then we're outside the scope of what we deal with.
Correct.
Chairman, Administrative Attorney Oneat Wilburn, I'm sorry, this is the trial attorney in me. My biggest problem here is that Mr. Eaton is saying he can't even remember that night. So he very well could have given that big of a tip. So we have no evidence disputing that he did.
Also, Chair, I'd like to make a note, because I feel it's important. Supervisor Brown brought up some inconsistencies. The Metro Police report indicates it was a taxi ride. It doesn't even indicate that it was a limo ride. Mr. Eaton filed a report and said that it was a taxi ride, which actually puts it under the purview of another state agency, not us, within Clark County.
Correct.
If I
All right.
may.
Your final closing comments, Mr. Eaton. I'm gonna give you just about 3 minutes more, and then we're gonna make a decision here. Go ahead.
Yes, of course, sir. At the time of filing the police report, I had little to no information. I don't remember being picked up. I don't remember being dropped off, and I don't remember the driver. Everything that I was able to put in the police report was gleaned from speaking with the driver and my recollection before I was picked up and dropped off. One more thing I'd like to add. If there was urination in the vehicle, then it would seem odd that the driver is driving me from location to location when the vehicle has been damaged with urination. That seems inconsistent. So I would like to say that any inconsistencies with the police report were because I did not have all the facts at the time. Those were the facts as I knew them at the time. I was at the Rio Casino, and that's where I thought I was picked up. So they're not inconsistencies. They're inconsistencies because I did not have all the facts. My allegation is the driver took advantage of me because I was so intoxicated that I couldn't tell what I was doing.
Okay.
And the
All
fact
right.
that he can charge any amount that he wants through a personal account, and he doesn't transfer that money to his company seems to me to be a major red flag. If there was damage, BLS would demand that they be compensated for damage to the vehicle.
If there was damage.
If there was damage, so I'm being driven around in a vehicle damaged by urine. I mean, the limo driver is held to a higher standard.
And Chairman, Administrative Attorney Oneat Wilburn, I've read this report pretty thoroughly, and I've spoken with Investigator or Supervisor Brown. The statement just that the limo driver charged this much, we actually don't have something saying he charged this much. There's nothing saying that he demanded this amount of money. It's just the amount of money that was paid.
Yeah, no, and that's what I was looking for. That was my point. There's
That's
no.
the problem. They haven't provided anything.
There's no evidence. All right, Mr. Eaton. Commissioners, I'm looking for a motion. What would we like to do on this formal complaint?
I think we should at least have a hearing and be heard out.
Commissioners,
Chair, my motion would be to, I'm guessing, trying, is to deny the request, right?
It's to deny the formal written complaint to move
Or
forward. to hearing.
dismiss them, yeah.
Or
Or to
dismiss it.
dismiss,
Dismiss it.
dismiss.
Yeah.
Dismiss the formal complaint.
Based,
Yeah, so that-
based on Mr. Teddy, would you say because this is civil litigation and does not fall within the purview of NRS 706 or NAC 706?
I would,
Is that part of your motion?
yes, we can make that part of my motion.
Can you just make the? Okay.
Sure, so my motion would be to dismiss the formal written complaint. Because I guess the basis of the complaint falls be what,
May I help you?
yeah, please.
So,
Part of the agenda items,
no, so for the record, Jessica Guerra,
the decision.
So-
of the formal-
so the motion would be to dismiss the formal complaint for lack of subject matter jurisdiction.
Okay, yeah, and I will accept that as my motion.
You,
Subject matter jurisdiction. Thank you so much for that legal.
No,
Can I amend?
yeah, I don't love that wording.
Can I,
Go, please. We'll let Louis go ahead.
So- so I would move, Mr. Chairman, that we dismiss, that relative to agenda item 120, docket number 25-11031, that we dismiss the formal complaint as not having met the probable cause standard pursuant to NAC 706.3978, provided that
This is it.
provided that such dismissal is without prejudice. The reason I'm including the language without prejudice is because if he goes to court, this gentleman, the complainant, I don't want him to be able, any further action be barred by us and taken out as the, either the company or driver. If it turns out that in his civil action, he's successful. So that'll be my motion. Thank you.
I will second that motion, just Commissioner Zoka's eloquent motion.
Okay. We have motion by Zoka, second by Teddy. Is there any public comment in Las Vegas?
No one here in Las Vegas.
Okay, okay. There's nobody in Reno. All those in favor, please signify by saying aye.
Aye.
Motion carries unanimously. Mr. Eaton, thank you. We're sorry for this. There's nothing more that we can say, but this falls outside of our purview. Thank you, sir.
I would just like to make one more comment if I may.
You can
I'm
do that
concerned-
under public comment on the next item, Mr. Eaton, where this item is closed.
This sets,
That's gonna take us to item number 121. Go ahead and sit tight, Mr. Eaton. Mr. Eaton, sit tight for just a moment. We're now at item number 121, public comment. Public comment is welcome at this time, is limited to 3 minutes per person. It can be on or off the commission's agenda. So Mr. Eaton, go ahead, give me 1 second here. And the floor is yours. You have 3 minutes, sir.
oh yes, thank you, sir. I'm just concerned about the precedence this sets. If a passenger is so intoxicated that he can't control himself or his bodily functions, it enables a nefarious limo driver to charge a credit card of an intoxicated passenger, basically what he wants. $1,500 is obscene. And then to add a $300 gratuity, and there's no recourse. I guess the only recourse from this committee is to, take it as a civil matter. The license is provided by this authority, and it's very disturbing that, someone can charge basically whatever they want. It's, really upsetting, and, I'm just concerned for other passengers in this situation. He didn't let me know he was employed by BLS. He didn't provide, a written receipt. BLS is supposed to inform this body of any complaint 2 days. That didn't happen. And he also has a duty of fair dealing, honesty, and he's held to a higher standard. So I'm just upset, at the president's, this sense. I respect the authority's decision, and I'm just upset with the, the precedent it sets that a driver cannot be held accountable when on its face, The charges are just obscene. Even assuming I did give a $300 gratuity, I was so intoxicated that, it shouldn't, he shouldn't even accepted it. If he wasn't, an honest, limo driver. I'm just very upset about the precedent it sets, and, I feel bad for, anybody else in my situation who has to go through this and, is without recourse. Thank you.
Thank you, sir. Is there anyone else under public comment wishing to speak at this time?
There is no one here in Las Vegas.
There are
Anyone
no
online? I'm sorry.
online chair.
Okay. All right, we will close public comment and bring it back to the board. That takes us to item number 122. Commissioners, we are adjourned. Well done.
Thank you, Chair.
You know what?
Happy holidays.
Thank you, Mr.
Thank
Chairman.
you. Thank you.